very brief, just
Okay.
to make a record since I've gotten ready twice for this. All right. May it please the court, again, Tim Sanders on behalf of the Appellate, Douglas Stolley. It's brief, there was initially two orders that were appealed in this, filed in the notice of appeal, which even at the time, Ms. Henderson arguably did not even have standing to file the appeal. She was not even a party in the case any longer. Her claim had actually already been dismissed. But this court has already dismissed the first order that was appealed, which was the motion to dismiss that was denied previously. And now we're just here on the, it was an order ordering the disbursement of the attorney fees to the guardian and the guardian's attorney. We have a valid, the hearing was held by Judge Sisko in December 2012. We have a valid contingent fee agreement for a 40% attorney fee, which was found to represent Douglas Stolley as the guardian over the property, the minor, Evan Cobble. Judge Sisko at the hearing, she took judicial notice of the statute, section 744.108, in which any services that are rendered by the guardian or the attorney on behalf of the guardian that provide any benefit to the ward are allowed the reasonable attorney fees and costs. Judge Sisko relied on substantial competent evidence, and it's my understanding that according to the case law, any disputes regarding attorney fees and costs are to be, there's a abuse of discretion standard, and here we're not dealing with the interpretation of the statute. The statute reads pretty clearly. You know, the appellate court is supposed to defer to any substantial competent evidence relied upon by the lower court, which here we have the evidentiary hearing was conducted. Judge Sisko properly found that our attorney fee, 40% for this contingency fee case, was reasonable and customary in the community. There was previous expert testimony by Mike Tonelli, an attorney, who found that 40% is a reasonable fee. And also the contingency fee contract that was entered into between Mr. Stolley and Mr. Ligori was also entered into evidence. And in fact, the defense attorney at the time, George Vaca, actually he didn't have any dispute that 40% was reasonable and the costs were reasonable. The only dispute was whether we were entitled to that attorney fee. I really don't think that's an issue. You know, like I said, there's no abuse of discretion here. There's some issues about whether, well, basically in their brief, their entire argument as far as the fees order relies solely on, well, if this initial motion to dismiss would have been granted, then then Mr. Ligori and Mr. Stolley would not have provided any type of benefit to the ward, which that's a moot point now. The standing issue has already been dismissed by this court. So I will leave it brief, but I would respect.
Everybody signed a settlement agreement, didn't they?
Yes, and that's a great point, Your Honor. This case has already been mediated and settled. Ms. Henderson was present. Her attorneys at the time, they all agreed, and in the agreement they actually agreed that any further disputes as far as attorney fees and costs and who's entitled should be in the jurisdiction of the circuit court, which was Judge Sisko at the time. Judge Sisko actually made the ruling in December 2012, and it's the order we're here that's being appealed. And essentially they didn't like her ruling, and now they want to keep trying to appeal this and prolong this litigation. It's been very contentious, long-standing. You know, the real party in interest is the child here. I don't see how any of this litigation is benefiting the child. It's just adding to further long-standing litigation. So I'll leave it at that unless any of your honors have any questions for me.
Good. Thank you.
All right. Thank you very much for your time.
Take care.
Thank you.
With that case.